At the conclusion of this lecture, you will be able to understand administration as a general alternative to liquidation. You'll be able to understand the way in which an administrator may be appointed, the effects of such appointment, and the powers and duties of an administrator. Administration was first introduced in the Insolvency Act of 1986. The aim of the administration order is to save the company, or at least the business, as a going concern by taking control of the company out of the hands of the directors and placing it in the hands of an administrator. Alternatively, the procedure is aimed at maximizing the realized value of the business assets. Once an administration order has been issued, it is no longer possible to commence winding up proceedings against the company, or enforce charges, retention of title clauses, or even hire purchase agreements against the company. This major advantage for the company has been undermined by the fact that an administration order cannot be made after a company has begun the liquidation process. Companies are required to inform any person who is entitled to appoint a receiver of the fact that the company is applying for an administration order. It is open to any secured creditor to enforce their rights and to forestall the administration procedure. This will cause the secured creditor no harm, since their debt would more than likely be covered by the security, but it could well lead to the end of the company as a going concern. A director will be viewed to have breached his or her duty to the company if it is found that they have failed to pay under a county court administration order under Section 12 of the Company Directors Disqualification Act 1986. This can warrant a disqualification order for the director in question. For the purposes of most of the Company Directors Disqualification Act, the court has discretion to make a disqualification order. However, if a person has been found to be an unfit director of an insolvent company, the court has a duty to make a disqualification order. The Enterprise Act 2002 introduced a new scheme, which limited the powers of the floating charge holders to appoint administrative receivers, whose function had been essentially to secure the interest of the floating charge holder who had appointed them, rather than the interests of the general creditors. As compensation for this loss of power, the holders of floating charges are given the right to appoint the administrator of their choice. If the company has little in the way of assets, poor cash flow, and no future, then creditors' voluntary liquidation is probably more appropriate than administration. There are two types of application to the High Court. There is the without court order appointment route for holders of qualifying floating charges and companies or directors. The company can enter administration in order to be sold to other companies, in order to maintain its existence in some format. The administration period is usually 12 months, although this may be extended by 6 months with the approval of the creditors, or longer with the approval of the court. When the administrator concludes that the purpose of their appointment has been achieved, a notice to this effect is sent to the creditors, the court, and the company's registry. Such a notice terminates the administrator's appointment. If the administrator forms the opinion that none of the purposes of the administration can be achieved, the court should be informed, and it will consider ending the appointment. Creditors can always challenge the actions of the administrator through the courts. The administration process requires a licensed insolvency practitioner to act as the administrator appointed by the court. The court-appointed administrator takes over the management of the company and takes responsibility for restructuring the company or business. The function of the administrator is to rescue the company as a going concern, or to achieve a better result for the company's creditors as a whole than would be likely if the company were to be wound up, or to realize the value of the property in order to make a distribution to the secured or preferential creditors. the administrator is only permitted to pursue the third option where he thinks it is not reasonably practicable to rescue the company as a going concern, and he thinks that he cannot achieve a better result for the creditors as a whole than would be likely if the company were to be wound up, and, finally, if he does not unnecessarily harm the interests of the creditors of the company as a whole. During the administration process, the administrator has the powers to do anything necessary for the management of the company, remove or appoint directors, to pay out money to secured or preferential creditors without the need to seek the approval of the court, to pay out money to unsecured creditors with the approval of the court, to take custody of all property belonging to the company, to dispose of company property. This power includes property which is subject to both fixed and floating charges, which may be disposed of without the consent of the charge holder, although they retain first call against any money realized by such a sale. What are the advantages of administration? Administration can be a very useful and powerful tool for insolvency practitioners to control the company, banks, and creditors to ensure the survival of the business. All legal actions are stayed by the process. It stops the financial position getting worse and the directors being put at further risk. It can be very quick and cost-effective. All unsecured debt is removed. From the creditor's perspective, because a licensed insolvency practitioner is appointed to administer the company, it also ensures that the administrator considers all creditors' positions correctly. Protection from creditors can allow the administrator a reasonable time frame to negotiate a deal to achieve the objectives. This may include selling the company to protect jobs and economic activity. What are the disadvantages of administration? The directors are not in control of the business, and an offer from a third party may lead to their removal as directors. Tax losses can be lost. Another buyer may purchase the assets. It is a public event. All creditors and all correspondents must say XYZ Company Limited in administration. Most customers and suppliers will therefore become very aware of the insolvency. All orders must be ratified by the administrator or his staff. The directors have no powers to run the company. As soon as reasonably practicable after their appointment, the administrator must obtain details of the company's creditors and must notify the company and all of its creditors of his appointment. However, this can also be an advantage as it stops legal actions. The appointment must also be advertised in the London Gazette and in a relevant local or national newspaper, one that the administrator thinks is appropriate for ensuring that the appointment comes to the notice of the company's creditors. Costs are often very high for this procedure. Financing trade and other supplies can be difficult unless adequate resources are available, and/or new funds can be introduced in the administration period. In conclusion, the purpose of administration is to save the company existence. It was introduced in the Insolvency Act of 1986. The process can begin on request of directors, company, or holders of floating charges. The procedure lasts usually for 12 months, but can be extended. The administrator is appointed to carry out the process.